have been an increasingly important part of the retail financial services market since the first class order was promulgated in 2004. And IMAP has conducted a number of fund surveys over the last couple of years, culminating in a survey for the 30th of June, which shows that they are now at least a $30 billion part of the retail financial services market. So currently about 5%. And I think we underestimated the true value of FUM included in managed discretionary account type services. So the regulations which ASIC have now refreshed are extremely important as a set of signposts and guides for the way in which this class of service or product is going to be offered to retail investors over the next decade or so. For myself, when I read the new regulatory guide and the new instrument, I thought what a well-written piece of regulation it was, and I think it was a tribute to ASIC that through the consultation process which began in 2013 and which took place then in a number of meetings between IMAP and its constituents, and I know a number of the other industry organisations, it's clear to me that the input which we as a group of financial service providers and licensees, that the input which we gave to ASIC was actually listened to and was then reflected in the regulations which we now have. It seemed to me that in brief summary, what ASIC's done is said, well, we created MDAs a little over a decade ago, didn't quite understand how they would be used by the advice industry and investment managers and the platform industry, but actually as we see how it's played out, we've recognised the variety that has come to be embedded in this type of service, and we're comfortable to provide a supportive environment for that variety. So we have on today's webinar people attending from Sydney, from Melbourne, from Brisbane, and there are also a number of people who couldn't be in one of those three centres attending through a webinar as well. The format of the presenters that we're going to have today are Tony Christie, who's a senior lawyer from the strategic policy area of ASIC. In Sydney we have Claire Wyville-Plater from the Fold Legal, and in Melbourne here David Court and Matthew Toomey from Holly Nethercote. I'm chairman of IMAP, Toby Potter, and in Melbourne, in Sydney, Brett Sanders will be moderating and managing the questions as they come up. The format for the session today is this introduction, presentation by Tony of the thinking that went into the drafting of the new regulations. Then some discussion by David and Matthew here and Claire in Sydney of some of the consequences and some sort of first thoughts, if you like, based on a month or two of consideration, or a month or so of consideration and feedback from people who are already involved, and then questions from the floor. So we'll be managing this between Sydney and Melbourne. So excuse us if the strings sometimes show. We should wrap up by about 5:30, and then there's a little refreshments provided by Macquarie. So let me say that on behalf of IMAP, we'd like to thank Macquarie for facilitating this presentation, in providing the facilities and in providing the video conferencing capability. This is the first time we've actually tried this type of event. Very fraught, let me tell you. But as I say, we'd like to thank Macquarie for providing their facilities. Please keep questions to the end, as would set aside a specific question time for that. So, without further ado, let me hand over to Tony Christie from ASIC. Thank you very much.
Thank you, Toby, for the introduction and the opportunity to speak here today. I've been asked to talk about the purpose or intent of the new changes to the way we regulate managed discretionary accounts. I also talk about the transition periods for implementing the new reforms. Firstly, MDAs on a regulated platform or limited MDAs. As you know, we have revoked the regulated platform no action letter. The no action letter allowed advisors to transfer funds on behalf of investors on a discretionary basis between investments without having to hold an MDA-specific licence authorisation. MDAs on regulated platforms will now be regulated like other MDAs, although we will provide additional relief to avoid imposing duplicate requirements. The original intention of the no action letter was to facilitate portfolio rebalancing between managed investment options. Since that time, MDAs on regulated platforms and indeed regulated platforms themselves have become much more sophisticated. We no longer think that it's appropriate to distinguish the regulation we impose based on whether the MDA is provided on a regulated platform. Indeed, as part of our regulatory review, several respondents raised concerns that the regulated platform no action letter created a less onerous regulatory regime for some MDA providers. Under the no action letter, MDA providers on a regulated platform were not required to hold an MDA-specific licence authorisation. As a result, there were a number of licensees who we did not know whether they were providing MDAs or not, and therefore there was a large sector of the market that was largely opaque to ASIC. For investors, there was a discrepancy between the documented licence authorisation and the services provided. The major change for MDA providers on a regulated platform is that they will be required to hold an MDA-specific licence authorisation to deal by issuing. We think that this will improve transparency, will provide greater comfort and certainty to industry, and facilitate confident and informed decision making by investors. I think Claire and Matthew may talk more about the licence authorisations. Wherever possible, we have attempted to facilitate the concurrent provision of an MDA and the regulated platform by not imposing duplicate requirements. The MDA provider does not have to comply with the quarterly reporting obligations or the annual transaction report and audit report if they are provided by the regulated platform. They also don't have to retain those documents for a period of 7 years. We think that the new regime balances the requirement to not impose duplicate requirements, but also ensures that investors who invest in MDAs on regulated platforms have adequate protections given the significant level of control that the MDA provider has. We have given MDA providers on regulated platform a reasonable period of time to transition to the new requirements. If you were relying on the regulated platform no action letter as at the 1st of October 2016, you will have until 1 October 2018 to implement the new reforms. If you're a new provider on a regulated platform after 1 October 2018, you'll be required to comply with the new obligations at the time of obtaining the licence authorisation. But I'll talk more about the transition period at the end. Next, we have introduced new requirements or provided further clarity about disclosure obligations. Disclosure plays an important role in encouraging confident and informed consumer decision making. We now require that MDA providers must include more detailed disclosure about the investment strategy, the fees charged within the MDA, outsourcing arrangements, and how the MDA contract can be terminated. Some of these requirements make explicit requirements that we think were already implicit. For example, we already think there was a requirement to include information about fees and costs in the FSG that's consistent with Schedule 10 of the Corporations Regulations. It's also important that the information about fees and costs are included in the MDA contract because they govern the relationship between the MDA provider and the client. Other disclosure obligations are new. For example, we believe that for the MDA to run efficiently and effectively, MDA providers should have policies and procedures to ensure the orderly exit of clients. Disclosing these policies to investors upfront in the MDA contract will ensure that they know what to do if they wish to terminate the MDA contract, how long it will take for termination to take effect, which can't be more than reasonably necessary, and how the client's assets can be transferred if they're not held directly by the client. Turning now to our new requirements for investing in non-limited recourse products. In our MDA review and consultation, a number of respondents raised concerns or identified as a significant risk in the MDA sector, MDA providers who are investing in high-risk financial products. Some MDA providers invest in contracts for difference and other leveraged OTC derivatives on behalf of their clients. Depending on the size of the investment and the degree of leverage involved, investors can suffer significant losses in a very short period of time and may end up with losses that exceed their client portfolio, requiring additional contributions of funds. Because the provider can make discretionary decisions on behalf of the client, the investor may not be immediately aware of the positions held or margin calls or losses or other adverse events. Further, the investor is not given the PDS for the underlying products, so they may not appreciate the risks involved in investing in highly leveraged financial products. Our regulatory approach seeks to balance the need to allow MDA providers to have the flexibility to structure their MDAs to suit the client's interests with the need to protect and ensure investors are informed about the specific risks involved in investing in non-limited recourse products. MDA providers must seek written consent before they invest in a non-limited recourse product, and the consent must include specific disclosure about the risks and about the MDA provider's policy about communicating things like margin calls and closing positions at a loss. To help minimise the regulatory burden, we don't anticipate that MDA providers will be required to seek consent on a transaction-by-transaction basis, and if the client is willing to accept the risk of a non-limited recourse product of the same kind. The MDA provider must also include specific disclosure in the FSG and MDA contract about the specific risks. Next, we have provided additional guidance on managing conflicts of interest. An MDA provider can be subject to a number of material conflicts of interest in the course of providing an MDA. Most enforcement action that ASIC has investigated involves inadequate management of conflicts of interest by MDA providers or their advisors. To assist industry, we have provided more detailed regulatory guidance about our expectations for MDA providers to manage conflicts of interest. Our guidance will cover their specific obligations, for example, the requirement under our relief to act in the best interests of the client in providing the MDA, which of course is an additional and specific obligation to the requirement for advisors to act in the best interests of the client in providing retail advice. There's also the specific obligation and our relief to prioritise the client's interests if there is a conflict of interest, and we also give specific guidance about the general obligations to manage conflicts of interest under Section 912A of the Corporations Act. These specific conduct obligations are important. For example, the duty under our relief to prioritise the client's interests in the case of a conflict means that in most cases something like disclosure will not be adequate on its own to manage conflicts of interest, and the provider will need to think of other measures, for example avoidance or control. The regulatory guide provides pretty comprehensive guidance on these requirements and is intended to supplement our general guidance in Regulatory Guide 181. Next, a requirement that has apparently caused a little bit of concern. If an MDA provider includes in the MDA contract an investment program prepared by an external MDA advisor, they're required to review the statement of advice in relation to the investment program before entering into the MDA contract, and not enter into the MDA contract if they have reason to believe that the MDA is not appropriate for the client's relevant circumstances. We don't believe that this is a particularly onerous obligation. We make it clear in the regulatory guide that we do not intend that the MDA provider has to undertake a comprehensive review of the investment program, and we do not envisage that the MDA provider is endorsing the investment program. It's really just there to deal with the circumstances in which the MDA provider may have additional knowledge about their product, or indeed may have additional knowledge about the client's relevant circumstances that the advisor does not have. Just a couple of those. Next, I'll touch briefly on financial resource requirements. As you know, we consulted on a proposal to update the financial resource requirements for MDA providers to ensure that these requirements correspond with the requirements that we impose on responsible entities of managed investment schemes and platform operators. At this stage, we do not intend to impose those obligations, and we'll review this over the next 2 years. We still believe that it's important that MDA providers maintain adequate financial resources to operate their MDAs effectively and efficiently. However, we acknowledge that in some respects the risks for MDAs, for clients of MDAs, are unique because the investor retains the legal or beneficial ownership. There's also an argument that there should be different obligations imposed for MDAs on regulated platforms. We intend to review these requirements over the next 2 years. As I mentioned earlier, a large sector of the market is opaque to ASIC, so once we start receiving applications for licence authorisations by regulated platforms, I think we'll have a better picture of the obligations we'll be imposing, and then we intend to consult again on imposing financial resource requirements, or indeed not imposing financial resource requirements. I encourage you all to participate in that consultation process. Finally, I'll talk about implementing the new requirements under the instrument and RG 179. If you are an existing MDA provider at 1 October 2016, you'll have until 1 October 2017 to implement the new requirements. If you are a new provider after 1 October 2016, you must implement the requirements as at the date of authorisation. In relation to regulated platforms, as I mentioned, you'll have until 1 October 2018. Finally, in conclusion, I'd like to emphasise the importance of industry and regulators working together to ensure continued trust and confidence by investors in MDAs. Without trust and confidence by investors, you won't have a market for MDAs. I'm happy to take any questions, but as Toby mentioned, we'll leave that to the end. So I'll hand you back to Toby.
Thank you very much. Look, thank you very much, Tony. And just to pick up on the last point that Tony made about organising consultation, IMAP was central to coordinating a number of participants' involvement in the consultation process in 2013. And I see it as important for us to be involved over the next 12 months and then in the period following that in working with ASIC and with our own members to make sure that the range of views are properly and adequately expressed to them. Now, as I mentioned, the sort of format now is that I've invited Claire Wyville-Plater from the Fold Legal in Sydney to have to express a few thoughts, and then following Claire, David Court and Matthew Toomey from Holly Nethercote, and then we'll take questions both from the legal presenters and from the floor, and Tony will have a go at dodging them. I can't believe I said that. So if I can hand over to Sydney now.
Thanks, Tony. My name's Claire Wyville-Plater, and I've been working quite closely with IMAP and various MDA providers for the last 5 or 6 years now. I have to say, I think that this clarification in the regulatory guide and the new instrument are most welcome. I think to me, one of the most useful things is that there is now a very clear distinction between who is considered to be the MDA provider, who is actually the external MDA advisor, and when an advisor who recommends an MDA is not an external advisor. And so I think a lot of clarity flows from that. The short point on those is that basically the MDA provider is whoever it is that exercises the discretion. And it's that simple. You're exercising the discretion, you will be the MDA provider. Whereas, to be honest, under the previous guidance, I had different views, so I'm very happy with that clarification. The external advisor is a person who recommends the MDA service and prepares the investment program. And again, that's very helpful as well, because there is some lack of clarity around whether someone who simply recommended an MDA service is and didn't prepare the investment program was an external MDA advisor. So that clarity is very welcome. Where I think some further guidance would be helpful from ASIC is in relation to exactly what authorisations each of those people will require in relation to the MDA services themselves. And I know this is a question that's going to come up, but the difficulty that we're having is that the regulatory guide says that they will need an authorisation, the MDA provider will need an authorisation to issue either a managed investment scheme limited to MDA or a miscellaneous financial product, including an MDA. But what it doesn't do is say in which circumstances those two things are required. And Tony, I know you're on notice of this question, so we're really hoping you can answer that for us, because I think that has quite considerable flow-on effects in relation to the product authorisations that both external MDA advisors will require, and indeed financial advisors who recommend MDAs services but don't necessarily prepare the investment program. So we're really hoping you can give us some sheds of light on that later, Tony. The other thing that I think are, I guess, interesting issues that we would like some more clarity on are, first of all, the Financial Services Guide. There are some quite a number of new disclosure requirements in the Financial Services Guide, and what's really good about those, to be honest, is that it's very clear that that is just the Financial Services Guide of the MDA provider themselves. That relates to the organisation providing the discretionary services. So my view is that clarity is very helpful, but at the same time, there's a lot of information to be provided in that Financial Services Guide, much of which is then repeated in the MDA contract. And when I was working with IMAP to put together that submission that we put to ASIC, we did actually recommend strongly that that be streamlined because we felt that the key information that would be required should be in the NDA contract so that it would provide to the client at the time that they were making their decision about whether to enter into the contract. So I guess, obviously the industry will comply, but I think that's a bit of a missed opportunity to have streamlined some of that information requirements. And that being said, one of the key issues I think that I see out of the additional disclosures is the requirement for fee disclosure. And I, again, appreciate the guidance from ASIC on that because what the regulatory guide says is that the fee disclosure information, which is provided in both the Financial Services Guide and the NDA contract, must be the same as would be required if it was managed investment scheme. Now, the managed investment scheme fee disclosure information is actually very prescriptive in terms of its form. And my concern is that this won't be particularly helpful or useful in the context of an NDA contract or FSG, where the framework and the circumstances are really very different. So, Tony, if you can give us some implications, some guidance on that, that would be very helpful. Another issue that we have, and we have designed NDA contracts and investment programs and SOAs, will no doubt have come across this, but there's quite a lot of overlap and intertwining of the information that's required in those three documents. So, for example, the investment strategy must be set out in the NDA contract. But of course, by its nature, it also must be set up in the NDA, in the investment program. So it would be nice to have some clarity about whether that can be incorporated by reference or whether it actually needs to be duplicated. It also seems odd that the investment program needs to set out the following issues, which it would seem to me are more relevant to the NDA contract, and they would be the significant risks associated with the discretion under the NDA contract and the strategies applied in exercising those discretions, and also how the client will give instructions to the NDA provider and by whom the suitability of the NDA contract will be provided. It seems to me that they are probably issues which would be more relevant for the statement of advice, and so again, it would be great to have some feedback on that. And then finally, I think these disclosure statements are really interesting. It's good to have clarity that they will be required in relation to ongoing advice, but I query and this has implication, Tony, as to whether, given that the NDA provider, in reviewing the suitability of the NDA client, and also in providing ongoing investment advice in terms of the selection of investments, whether that would be considered to be an ongoing fee arrangement in relation to which a fee or an ongoing fee disclosure statement needs to be provided to the client. It would seem unusual that that would be the case where there's an external NDA advisor, but again, we could have some clarity on that. So they're the key issues, I think, commercially, or in terms of implementation of the class order. Not all of those issues have come out in the regulatory guide. They do require fairly careful reading of the class order to elucidate. But hopefully, Tony will write on this a bit later. Thank you.
Thanks very much, Claire. And now I'd like to call on David Court and Matthew Toomey from Holly Nethercote.
Thanks, Toby. I'm David Court, partner at Holly Nethercote, and Matthew's one of our lawyers who does a lot of MDA-related work. I'll just give a few big picture type issues that have occurred to me, and Matthew will just address a few of the more detailed issues. So I think just from a big picture perspective, the new MDA class order has good aspects and it's got bad aspects. The good aspects is the product design now is not radically different to what it as always has been. And if you're happy with operating under the current or the pre-existing environment, then this really isn't going to mean a huge change to your product structure or your product design. It's going to require tweaking around the edges and things like that. The big thing for existing providers is there's no regulatory capital requirements, which I know was a big issue, and to some extent, I think you've dodged a bullet there, although whether I think ASIC's just put it in the too hard basket and it's going to come back for another go, we'll have to wait and see on that. I think the bad side of it is really the same as the good side, that it really hasn't changed. And if you want to move and develop your MDA product, you're really stuck in the same product design that's been around since 2003, 2004. And this is a particular issue, I think, for the robo-advisors. People who are operating automated trading programs or robo-advice is they have to come under the MDA class order because it's really the only way that they can rebalance portfolios and do that aspect of discretionary trading. And I think that the class order as it operates at the moment is just too clunky for them, and it just creates all these mechanisms that really don't work in an environment when you're trying to do an online straight-through processing arrangement. And I think that's probably one of the disappointing aspects of this is that ASIC didn't really consider, and I'm not sure whether they were asked to consider, whether we should actually have a separate MDA type product that suits robo-advising better. And that's something I think we'll want to look at in the future. So, as I said, I think if you're happy with the current arrangement, then I don't think ASIC's changes really should hold any great fears for you. If you're currently acting under the no action letter, sure, you're going to have to come in within the system and be licensed and have the authorisations, but technically you're already out there licensed. You've already got a license to advise and deal, and you're really just going to add another authorisation, put another arrow in the quiver, so to speak. So from that perspective, it shouldn't be too hard. There should be a nice transitional arrangement from ASIC, and hopefully from a responsible manager perspective, you'll get credit for the expertise you've developed over the years in running the product under the no action letter. So that should be a fairly seamless transition. So I'll throw it to Matthew just to raise a couple of other points that have occurred to us.
Yeah, so I think the responsible manager one is obviously a big one that people want to know, and it'd be great to get a bit of clarity around that. But I suppose something that we've been thinking about, something we've been fielding questions on is what do I have to do now if you're already operating and you've got to update your documentation and stuff by the 1st of October next year, what do you have to do? As has been mentioned, there needs to be a lot of additional disclosure in the FSG about how the MDA works. Any outsourcing arrangements that you may have that relate to the MDA have to be disclosed. And you also have to obviously update your significant risks associated with the MDA contract. And so obviously it's really important to review your MDA contract, investment plan and FSG as soon as possible, but in any event before next year. And I think particularly for people in Victoria, there's another sort of ancillary thing that happened last year. Those of you who have powers of attorney for your clients may be aware that the Victorian legislation around powers of attorney changed last year. And so if you haven't updated your powers of attorney in relation to that change in the legislation, it's probably worth having a look at that. Or in fact, you're legally required to have a look at that. And so it's probably a good opportunity to do that now. So things are quite seamless. For no action letter operators, obviously you've got two options. You can obtain a license or become an MDA advisor, and so obviously you have to give some consideration to that. But I think from our perspective, and certainly the questions that we're getting are around the disclosure, and as Tony said, I think the regulatory guide, and I think I'm in particular looking at 179.70, the conflicts of interest that need to be set out and the types of conflicts of interest that may arise are really clearly set out. And so obviously have a look at your documentation in relation to that. And I guess the other thing is, and I suppose we've had a couple of queries about this as well, is the non-limited recourse investments, if any of you are doing that. And as Tony mentioned, there does need to be a lot more disclosure and a lot more sign-off from clients than has previously been the case. So again, it's making sure you get your documentation in order in that regard. But I think those are really the key nitty-gritties that we've sort of focused on. I'm not sure if there's anything that I've missed.
No, and we're sort of happy to take the questions from the floor as and when.
So look,
time comes.
what we'll so thank you very much, David and Matthew. Now it's sort of open to the audiences in Sydney and Melbourne. I'm not sure if we've got Brisbane on the joined in as well. But let's start off with Sydney. Is there anybody in Sydney who has a question that they'd like to pose? Tony, it might be easiest if you come up here and we'll see how we go.
I'm doing it with it on my own, am I?
Yeah.
Well, perhaps I'll start by maybe addressing some of Claire's comments. In particular, the comment about the licence authorisation. I mean, she identified the fact that there are two dealing licence authorisations available. There's no magic to those two authorisations. It's a historical quirk of licensing. It reflects that we consider an MDA as both a managed investment scheme and a facility for making a financial investment. So there are no difference in the obligations that are imposed depending upon which licence authorisation you choose. I think, what was the other issues Claire raised? I think in terms of, I think there was issues about the investment program. I think you raised the issue that perhaps some of those, some of the disclosure in the investment program is more suitable to the MDA contract. Of course, the investment program must be included as part of the MDA contract, so you're kind of killing two birds with one stone in that regard. Claire, was there something else you wanted to?
Just going back to your first point, Tony.
Yep.
What would be really helpful is, in what circumstances would an MDA provider apply for the MIS authorisation, and in what circumstances would they apply for the miscellaneous financial product authorisation? Or is it truly either or?
Yeah, it really is either or. It does not matter. There are no implications by which authorisations you choose. As I said, it sort of evolved historically. We unfortunately didn't take that opportunity to get rid of one of those authorisations. I wish we had, but there are no ramifications according to which licence authorisations you choose. So they'll both be subject to the requirements under the instrument.
All right, well that's excellent. So are there questions perhaps from the Sydney audience for Tony or Claire, David or Matthew?
So it's probably touching what Claire said about the application process.
Perhaps if you introduce yourself as well, that would be.
Would it be not a better thing as an industry to have a standardised investment program, SOA contract, much like you have in the ISTA environment or the ASLA environment, like the investment derivative swap derivative? Would that not be a better thing? That's kind of what you were touching on before, wasn't it? Has that been considered by ASIC as being sort of IMAP?
Well, perhaps I can answer from the IMAP perspective and then to Tony, and that is my own experience in developing MDA contracts for a number of organisations is you inevitably try to capture the specific circumstances of that organisation and the thing, you know, for example, the relationships you have with either in-house investment management or external managers, the type of investments that you're going to include, you know, managed funds only or managed funds and equities, the platforms that you might use and the spread of platforms if you're operating on a regulated platform. So in a sense, you end up saying, well, you know, you start from where you are as an organisation and develop your agreement to support the service you want to offer. Would be my view.
Yeah, certainly in reviewing our requirements, we were very conscious of not imposing an overly onerous regulatory burden. So we didn't want to be too prescriptive about obligations. I know in relation to the investment strategy, there were some views that we should be quite specific about what should be included in the investment strategy. in the end, we just decided that you must include sufficient detail to permit the client to form an opinion about the suitability of the MDA and no more. And that was purely because we didn't want to impose too much regulatory burden on industry. I mean, you're kind of damned if you do and you're damned if you don't in a lot of these things, unfortunately.
What about the simple basics of the contract itself, rather than specific of the asset classes traded or investment itself, the standardised for pro forma of the MDA as such? Like we've assessed you, we've given you advice, we're basing the advice on this, and then the product itself or the underlying investment becomes like schedulised or an addendum kind of structure. Yeah,
well, I think that's something for the lawyers to resolve, or indeed, I'm sure Claire's got her precedents ready to go. And also perhaps, you know, industry like IMAP may be able to assist in that regard.
Yep.
Yeah.
That's a good point.
Well, thank you very much.
Thank you. Perhaps from Melbourne, are there questions from the audience here? Evelyn, yeah. So,
is there a question for Claire, Evelyn, or?
In general, probably with you,
oh, okay. Yep.
Previously clearly stated that the investment program would either be incorporated by reference in the contract and attached to the SOA, or whatever the choice may be. Is that still appropriate going forward?
Yeah, it must be incorporated as part of the MDA contract. That's a requirement of our relief. And the investment program may form the statement of advice, or alternatively you may provide a separate statement of advice. Obviously, if the investment program constitutes the statement of advice, there are some additional obligations you must meet in drafting your investment program.
Are there other questions? Yeah.
Question from Brisbane. Can you hear me?
Yes, indeed. Yes, excellent.
Tony Jeanette from Retirement Financial Planning in Brisbane. I run a limited MDA service through an IDPS. Would there be a specific extension allowed for just that capability? I don't wish to do anything more, and therefore I guess I'm asking, will there be more than one type of MDA extension with a specific one for that purpose? And secondly, given that we're likely to see various things pop up, as quite a few of the questions have been, is ASIC likely to further modify or clarify RG 179 and 2016/968? Thank you.
Firstly, in relation to will there be any particular concessions for an MDA provided on as, what was it, an IDPS? No, I mean, we made the policy decision that you were required to comply with the full MDA requirements after a lot of consideration, a lot of consultation on the issue. I think the only issue perhaps is the experience requirements that Matthew identified, and the fact that there may be some sort of shortfall in the experience requirements because you may not have experience in relation to the administration functions. That's the only thing that perhaps leaps out to me. As you know, there's a generous transition period of 2 years to perhaps obtain that experience, or bring in someone external, external consultant, to act as responsible manager. But also I think it's fair to say that licensing will take a reasonably facilitative approach to this, so as not to obstruct MDAs on a regulated platform.
And the other question that Tony raised was further review and sort of amendments.
Yeah, absolutely. I mean, that's certainly our intention, but unfortunately in a lot of these situations it's a resourcing issue. It's, you know, as you could appreciate, it's been a long process to get where we are with this class order and regulatory guide. We've committed to review financial resource requirements, and certainly over the next 2 years, if there are any glaring issues, obviously it's an ideal opportunity to consult on further reforms. In fact, Matthew identified robo-advice. We've got a regulatory guide out on robo-advice. It may be over the next 2 years that some issues really come to the fore on that front, and it may be something that we'd also consult on, but that remains to be seen.
Now, we had a question from the floor here, so...
Thanks. Do you anticipate having a different authorisation for MDAs on regulated platforms and MDA or just one?
No, it would just be the one authorisation, because there's no difference to the regulatory regime other than we provide additional relief, and that's done through the instrument rather than through licensing conditions. So there's no need to introduce a separate authorisation.
And your financial requirements are applied differently?
Yep. Absolutely, absolutely. They would be imposed probably by an instrument. So again, it won't impact on the specific licence authorisation that you obtain.
If I
just on the issue about financial resource requirements, it was a tough decision. I mean, as part of our process, we develop recommendations and take them to our regulatory policy group, which is constituted by commissioners and senior executive leaders within ASIC. And it's fair to say it was controversial, it was quite split. So I really would encourage people to respond to our consultation process and good submissions that substantiate the submission with detailed cost and benefit analysis, quantifying those costs and benefits, really would be helpful and would certainly help your submission.
Maybe can I sneak in with a question?
Yes.
So Brett Sanders from Philo Capital. Question for Tony. You said there'd be one form of authorisation. Can we confirm first of all that an advisor who is not an MDA provider but who wants to advise on MDA, they'll still have to get a separate authorisation to advise?
That's right. So they would need an authorisation to advise on an MDA, and they'd also need an authorisation to advise on all of the underlying client portfolio investments.
And in relation to those underlying investments, I think the updated RG says something along the lines of an advisor who is using a regulated platform would need to get authorisation for all the product types on the platform, rather than all the product types they intend to advise on. So just looking for clarity, if an advisor, for example, says, I only recommend managed funds in my regulated platform service, I have no intention of using listed securities, are they able to just get authorised to do managed funds and not have to have the competencies for listed securities?
Yeah, absolutely. I mean, your advice authorisation is just for the products that you intend to invest in, as set out in your investment program or your statement of advice. So you don't need to cover the field of the regulated platform. That's certainly not the intention in the regulatory guide, and I'd be interested to know, do you have a paragraph reference there?
I'll dig it out.
Yeah, that would be good to know, because if that is in fact in the regulatory guide, that's incorrect. I suspect it might be just an interpretation issue.
Another question in Sydney, if you don't have one elsewhere.
Hi, my name is Luja. I work for Super Concepts. We have a very small section of our business that deals with MDAs. My question is, I think, around what is the definition of an MDA provider? I think Claire said just before that it's about the discretion. Now, in the new regulatory guide, I think the definition of an MDA provider is somebody who enters into a contract to provide an MDA. So it doesn't specifically say it's about the discretion. And the reason I ask this question is because we use an external MDA advisor and we provide an MDA to clients. And the distinction between discretion getting the point that makes you a provider or not would actually have quite an impact on the way we run our business. So if it is about the discretion, so we have this advisor who will not only create the investment program, but continue to advise the client, and we'll very closely monitor the way in which we manage the MDA. So if we were to actually go and execute trades within the investment program, and we go back to this advisor and we confirm with them, these are the trades we're going to do, and we would never do a trade without their approval, they retain that discretion. So in that instance, on an ongoing basis with the advisor, an external party, very closely involved in the way we operate the MDA. Who is the MDA provider?
Well, you're right. The MDA provider is the person who enters into the MDA contract. The scenario you're describing sounds to me very much like it is an external MDA advisor. They're preparing the investment program, the statement of advice, and you are undertaking the investment based on the advice prepared by the external advisor. Was that?
That's correct.
Yeah, so you're the MDA provider and the other entity is an external MDA advisor.
The difference there being we would never exercise discretion. I think that's the crucial element there.
Well, you do exercise discretion within the confines of the investment program developed by the external advisor.
Sounds to me as though it's a circumstance which would benefit from a compliance specialist or a lawyer, and I'm sure there are several in the room giving you more or less formal advice.
And I think they've got their cards at the ready, Toby. Absolutely, absolutely.
Yeah.
That's right. Yeah. Oh, okay. Yeah.
So I think
The provider needs to deal by issue. Absolutely.
external manager, I think now it's clear that they don't have the whole, the authorization to deal with advice.
Absolutely. Yeah.
Now, I think we had another question here in the room.
Tony Gillette from Brisbane again. I just want to clarify that if I want to apply for an MBA extension and I only ever intend to deal through an IDPS, and can the licence be limited to that capability? In other words, I'm really asking, why should I have to have experience in administration when I never intend to do so and don't wish to do so? I always do it through an IDPS.
Yeah, I mean that's the policy decision we've come to. But having said that, I mean, as I said, we will try to facilitate the continued operation. So if you're able to satisfy the requirements of RG 105 in relation to experience, then licensing will facilitate your application. So I wouldn't be too concerned. Let's see how it unfolds over the next 2 years.
Right, a question from the room here in Melbourne.
Right, myself broken, run a couple of days or 2 hours. I just want to have 2 follow-up questions to players regarding, you mentioned that very, very important point about implications in all disclosure documents that had covered around, not just MBA. Yeah, so the first question on that, is there any plan to come to some sort of a resolution to cut all these documents down by hundreds?
Yeah, can I just quickly address that one and then you can go on to the next one because I'll forget your first question. You can incorporate by reference in some instances, for example, fees and costs. You can you include it in the FSG and incorporate by reference in the MDA contract, so that reduces that obligation. So you need to look at those obligations and get advice on that, but it may well be that although the obligations are duplicated, and they're duplicated for important reasons because that's governing the relationship with the client, between the client and the MDA provider. So, for example, in termination, we feel that it has to be included because that the client needs to be aware of their rights for terminating. But in relation to fees and costs, for example, you can incorporate by reference. So don't think that everything has to be, verbatim copied from the FSG back into the MDA contract. It may not.
Most units will never read any of these documents.
Well, that's the problem with disclosure, isn't it? That's a whole problem in itself. Absolutely, absolutely. But to some extent, disclosure is about mitigating your liability as well. So, you know, so it's there to protect you as well.
The second question really comes down to Kevin asked questions as far as, and also I suppose advising clients to consider MDA. And you mentioned that the MDA advisory authority is at the discretion of the Excel holder.
Sorry?
As an MDA license to qualify, say you have, for example, say Stephen Roker with 10 brokers, you have 2 MDA operators, some of the brokers like diversified clients, investments with some of the MDAs.
Yeah.
The specific MDA advisory authority, what is that?
A license authorisation is specific to advise on an MDA. Absolutely, absolutely. That's always existed, but hopefully it's clearer that that obligation does exist now. Yeah, you've always required a specific MDA license authorisation to advise on an MDA. Sorry? Oh, no. So it's like the licensee is required to hold that license authorisation, but their authorised representatives then can act under the authority of the licensee, and representatives can act under the authority of the licensee. It's the same as every other licence authorisation.
Please, yeah. Sorry,
Is this a question? Or?
No, this is just the question for Brisbane on what you do if you're acting under the no action letter at the moment. ASIC regards you as actually operating an MDA yourself, and so if you want to sort of become legit, so to speak, they'll want you to get an issuing authorisation, and they'll facilitate that through the transition period. I think if you're acting under no action letter, it's probably worth having a look at the other options as well, and that you could, if you're going to have to change your licence, well, maybe think, I've got the expertise to get a full licence, I'll go that way. Or the other thing is you might want to limit yourself and say, what I'm really doing here is the MDA advisor bit. I'm not doing the issuing. I'll find someone else, a product provider, who will do all that for me, and I'll just confine myself to what I do best, which is the advising part of it. And I think the answer there is probably just think outside the square a bit, that you do have a few options, and ASIC's giving you the opportunity to go down a particular course, a particular road, but if you don't want to do that, then you do have other options, and if you want to talk about them, come and call me.
Are there any, we've reached 5:30, which I said would be our wrap up. Are there any final questions for any of our 4 presenters today?
Tony, I've got a question from Sydney, for Tony, of course. We've lost over this a little bit, Tony, and I guess I just want to take you back to it, but because I foresee that there will be a good many licensees operating under the no action letter who will be very concerned about whether or not they will have sufficient experience to qualify to obtain a licence now that they need to apply for one. When we met with ASIC probably 2 or 3 years ago now, they made it very clear at that meeting that they felt that many people who were running an MDA under a regulated platform were unlikely to qualify under the new requirements to obtain a licence. And yet that seems, it seems inappropriate given that they won't actually be doing anything more than what they've already been doing for the last few years. So I guess it would be really helpful for those of us who will be asked by many clients to advise them on this, if you could give us an indication, because there isn't any in the guide, there isn't any in that RG 105, regarding exactly what requirements, experience ASIC will look for when someone is applying to run an MDA service under the regulated platform.
Yeah, it's difficult to respond to a hypothetical scenario because, you know, each application will turn on its own facts and merits. But, you know, you will need to satisfy the requirements in RG 105. We've made it clear that we will recognise the experienced obtained from operating an MDA on a regulated platform. The only issue that I see, and I'd be interested to Claire if you have any views on this, is perhaps the administration requirement. That may be, but as I've said, licensing have a view that or ASIC indeed has a view that, we want to facilitate the provision of MDAs on regulated platforms. So I think you can take some sort of comfort from that. So let's see how it unfolds.
Yeah, if I have an observation, it is that the difference in complexity between being a full-blown MDA operator where you're responsible for the administration yourself, perhaps appoint an external custodian, have the outsource obligations that come with that, quite different in complexity from operating an MDA on a regulated platform, and that it might be appropriate to consider having a condition in a licence that specifically speaks to operating an MDA service, but only in a regulated platform environment.
Yeah, we did actually consider a special licence condition that would confine you to operating an MDA on a regulated platform, but ultimately it was decided that that wasn't the appropriate route, that if you're going to have an MDA authorisation, we can't create a sort of a lesser beast, if you like, someone who, we're saying, well, they're not competent to provide a full MDA. So that was the decision that ASIC made.
Look, thank you very much. Now, please join with me in thanking each of our four presenters for what I think has been a very insightful presentation. So to quickly, to quickly wrap up then, upcoming IMAP events. So we have in the next couple of weeks another in our webinar series. This time on using separately managed accounts or managed account services for fixed interest investments. So I'd encourage you to participate in that. And to this point about the issues for limited MDAs, one of the things which IMAP is working up for early in the new year is a strategy workshop to enable those who are currently running limited MDAs to work through in a structured way the strategic issues which they face and the ways which they, in their particular organisation, may respond. So we'll have more on that strategy workshop before the end of the year. But it's clearly from today and from the conversations that we've had in the past an area of considerable interest for us. So thank you very much for your participation. That ends the video conference and webinar. Please join with me in thanking our speakers and enjoy Macquarie's refreshments. Thank you.